Hello and welcome to June's edition of Outline, DLA Piper's monthly planning law update. We've got a jam-packed agenda today. We've got lots to cover, but as usual, we will aim to keep within the hour. The first 45 minutes. I'm joined today by my colleague, an associate in the UK planning team, Henry Jeffries. So we'll be talking to you about some of the more interesting things, or the things that we think have been most interesting in terms of developments in the world of planning law in the last month or so. And then that should allow 15 minutes for questions at the end. If you do have questions, please do ask them as we go along. The Q&A box is live on your screen. If you type your questions in there, we will do our best to answer as many of them as possible when we come to that section. But without further ado, let's crack on. So we'll begin, as has become customary with these updates, with a quick reminder or a quick flag up of the legislative changes we've seen. There seem to always be legislative changes, which keeps us focused. The biggest one this month really is the changes to the development management that are flagged up on the first item on the screen. These are part of the response, the government's response to the Grenfell Tower tragedy, and these are introducing new requirements in the context of residential development that is either of 7 or more stories, or where the top story of the residential development is higher than 18 meters. If you're looking at residential development within that exceeds those thresholds, then these regulations will be relevant to you. The proposal, the regulations are in draft at this stage, but what the government is proposing is that applications that meet those thresholds will need to be accompanied by a fire statement. The draft regulations include a template fire statement, and that deals with matters such as the layout of the building, how water supply is provided for firefighting purposes, how access is secured for firefighting appliances, those sorts of matters. So a fire statement will need to cover those matters. The other change that the regulations are proposing is that the Health and Safety Executive are added as a statutory consultee for developments that are over the thresholds. As I say, at the moment, the regulations have been published in draft as part of a programme of changes that are being made, planning being effectively just one aspect of the new controls that are being proposed. At the moment, there's no fixed date for the regulations to come into force, but the government is targeting them coming into force on the 1st of August this year. So if you have relatively tall residential development applications that are in the offing over the next few months, do keep an eye on those regulations and make sure you know whether they apply to your development or not. The second regulations that we've seen come through this month are changes to the advertisement control regime and the advertisement regulations. They provide us with some exciting new rights if you're into flag flying. They allow the flying of certain flags without the need for planning permission, and if flags are really your thing, you can even fly 2 flags from one flagpole without the need for an express consent, provided you're within the detail that's set out in the regulations. I'm not going to go into the detail because frankly I don't think it's terribly interesting. That the highlights, if I can call it that, of the regulations are probably clarifying that if one of the flags you're flying is the Indian flag, then that flag must be flown above the second flag that you are attaching to your flagpole. That really is about as exciting as it gets. The regulations also remove from the list of flags that you can fly within the exemption, they remove the EU flag. So it's adios to our friends in Europe as far as the advertisement consent regulations go. That is probably as much as I should say on this topic, so I will very quickly move on. And I probably can cover the other ones even shorter. Some minor tweaks to the fee regulations are the third set of regulations we've had through this month. That simply introduces fees for certain types of prior approval applications, some of the new prior approval processes that we've talked about in previous months. So some minor changes to fee regulations there. And that is it for the legislative change this month. There's been quite a lot of progress on the Environment Bill. So look out, it looks as if we might finally have an Environment Act over the next couple of months. So watch out for more detail on that on future editions of Outline. But moving on to the next topic and the next slide, please. I wanted to just flag up and talk very briefly around a big policy announcement that we've had in the last month. And this is around the government's new flagship tenure of affordable housing, that is the First Homes version of discount market housing. This is effectively the replacement for the unsuccessful starter homes policy, which I understand didn't deliver a single home. So by any measure, it probably wasn't the biggest success of all time. As a result, the government have brought forward this new tenure type of first homes. The broad criteria for what constitutes a first home is set out on the screen. In terms of the eligibility criteria, the eligibility criteria broadly is that first homes will need to be sold to first-time buyers, and those first-time buyers have to have an annual household income that doesn't exceed £80,000 in the tax year prior to the year that they're purchasing the home, or if in London, an annual household income of not more than £90,000. A few points I wanted to flag up really on first homes. There's a lot of detail in the changes to the MPPG, which is where the policy has been brought in, and I've put the web address for the PPG on the screen. Also worth a read, if this is relevant to you, is the written ministerial statement that announced the policy change, and again I've put the web address for that on the screen as well. But in terms of the points I thought it was worth highlighting, firstly, there is an ability for planning authorities to introduce their own local eligibility criteria on top of the national criteria. In particular, there's some scope for local authorities, if they can demonstrate through their evidence base that it's appropriate, lowering those income thresholds if that is necessary. Also, the opportunity to prioritise key workers, and also the option to bring in local connection requirements for those looking to acquire first homes. If they do bring in local connection requirements, there's an exemption from those requirements for members of the armed forces, to ensure that first homes are available to them, notwithstanding their slightly more transient nature in many cases. Critically, though, that local criteria, if it is introduced, then it only, in relation to any particular unit, that criteria only applies for 3 months while the unit's being marketed. If at the end of 3 months, an occupier and a purchaser for the property hasn't been found who can meet those local criteria, then they fall away, and it's just the national criteria that would apply to that particular dwelling. The intention of the government is that subsequent sales of first home properties will need to pass on the discount, whatever level of discount, whether that's the 30% in national policy or a greater discount if planning authorities bring that forward. And also the intention is that the units need to be sold on to other eligible first-time buyers who meet that eligibility criteria. The idea is that that's secured through the Section 106 agreement at the point that the planning permission is granted, and that through that mechanism, a restriction is placed on the title of those units that ensures that those requirements are met. And the PPG even has a template of the restriction, which the wording of which has already been agreed with the land registry. So that should make the plot purchase process that much simpler. As I say, planning authorities are able to increase the discount if evidence supports this. They can either increase to 40 or 50%, depending on the evidence they can bring forward. They can also reduce, although they can't increase, the price cap from the 250 or the 420 outside of London. And I've mentioned up to now planning authorities, but actually one of the interesting things for me in the policy announcement is that all of these things, the changes to discount, the introduction of local eligibility criteria, changes to price cap, can also be brought forward by neighbourhood planning bodies through neighbourhood plans. That feels to me like quite a big area and a big responsibility to have put on neighbourhood planning bodies, and potentially makes the process of getting neighbourhood plans through the process quite important if they are proposing different criteria to those that apply elsewhere in a district. How is all this going to be brought forward? Well, the guidance indicates that the government is envisaging that it will be brought forward by planning authorities or neighbourhood planning bodies, either through interim policy statements or through reviews of local and neighbourhood plans. So I suspect initially we shall see over the coming months a flurry of interim policy statements looking to get the system in place and to get those local criteria in place. And then probably in the longer term, we will start to see policies coming through in updates to local and neighbourhood plans. The intention of the government is that first homes will account for 25% of the affordable housing that is provided by developers by way of planning obligations. But the question then becomes, if 25% goes to first homes, how do local policy tenure splits then apply to the remainder? There's some quite detailed guidance on that in the PPG that's worth reading if you're trying to think through the implication for the rest of the tenure mix for your affordable housing provision. Broadly speaking, I think it's fair to say that effectively the 25% in most cases gets deducted from the discount market and or the shared ownership element of any affordable housing package, and the social rent and perhaps to a lesser extent the affordable rent are protected. But that's a very broad rule of thumb, and it's certainly worth reading the guidance if you're trying to look at what the tenure split might be once you've put first homes into your affordable housing obligations. There are some transitional provisions that are worth flagging up. There is no need for local and neighbourhood plans that are submitted for examination by the 28th of June, so literally 11 days' time. There's no need for plans that meet that deadline to include first home policies. Equally, if the local or neighbourhood plan reaches the publication stage by the 28th of June and is subsequently submitted for examination by the 28th of December this year, then again, there's no need for those plans to be to include first homes policies. But if those dates aren't met, then there's an expectation in government that the plan will include first home policies. What does all of this mean for decision making? Well, where plans are adopted under transitional arrangements, there will be no need for first homes to be applied to planning applications determined under that plan until the plan is updated. However, inspectors are urged in the guidance to consider whether in those circumstances there's a need to require an early review of the local or neighbourhood plan in order to avoid first homes not being delivered in a particular area for potentially a very long time, given we all know that there can be quite a gap between the updates to and replacements of local plans. In terms of other planning applications where the transitional provisions for local plans don't apply, then the policy doesn't need to be applied to planning applications if they are determined by the 28th of December this year. Interestingly, that includes, according to the guidance, applications where a right to appeal for non-determination has arisen by the 28th of December. In those cases, then there is no need to apply first homes policy to the planning application. Likewise, if there has been what the guidance calls significant pre-application engagement, and the planning application that follows is determined by the 28th of March next year, there will again be no need to apply the National First Homes Policy to that planning application. There is a clue as to what significant pre-application engagement means in the guidance. Essentially, it means that there have been substantive discussions around tenure type and numbers of affordable housing units. So if that has happened in pre-app, I'm not sure many pre-apps go into that level of detail, but if it has, and that application is determined by the 28th of March 22, no need to apply first homes policy. Having said that, it may well be that applicants want to introduce first homes into planning applications that are caught by those criteria. If an applicant positively wants to talk about first homes policy and look to introduce an element of first homes into their affordable housing provision, then the guidance indicates that planning authorities would be expected by government at least to be flexible and to be willing to have that conversation. Last thing I wanted to say on first homes is, alongside first homes policy itself, we've also seen the introduction of a new concept of a first homes exception site into policy. We're all familiar with rural exception sites, but this is a new version focusing on first homes rather than other previous forms of exception sites. It doesn't apply in the Greenbelt, before anyone gets too excited. It also doesn't apply in certain other designated areas, national parks and AONB, for example. But elsewhere, it applies to sites adjacent to existing settlements and to sites that are proportionate in size to the settlement that they're adjacent to. In that sense, it's similar to the existing MPPF 71 policy, but there is a key difference, I think, between the two, in that if you're looking at exception sites under MPPF 71, then there are some criteria as to what constitutes proportionate size of settlement, etc. Whereas under this policy, the question of whether a site is adjacent to a settlement boundary and the question of whether it's proportionate in size to that settlement are matters of planning judgment. So there's a bit more flexibility there for people to argue that their site could come within the exceptions, the first homes exception site policy contained in the MPPG. The other big change, I think, that will be of interest to many that are bringing forward residential development or promoting residential development, is that first homes exception sites can include a small proportion of market housing in order to ensure that the site is viable. So I suspect that will make this potentially quite interesting for a number of landowners, and especially when you tie it with the last thing I'm going to say, which is that local planning authorities, pursuant under the guidance, are being told that the government will expect them to approve first homes exception sites unless they can show that the need that site is seeking to meet is already being met elsewhere. So potentially, in certain circumstances, if you have land that didn't have a big prospect of being brought forward for residential development, you may well want to look closely at that first homes exception site policy. It may well be quite a useful tool for landowners. So do have a look at the policy. As I say, the web address for that is up on the screen now. That was all I was going to say on first homes. So we'll move on to cases, and I will stop talking. You'll all be pleased to know and hand over to Henry. Henry's going to be talking to us about a recent High Court case which deals with the revocation of a certificate of lawfulness, which is quite a specific issue, but it does raise some interesting points more broadly, I think, around accrued rights and around the grounds for revocation of a certificate. So Henry, I think this related to a proposal from Ocado, didn't it, for a distribution centre?
That's right, Trevor, and good morning, everyone. So as you say, the first case update is around Ocado, the supermarket distributor. The judicial review of the London Borough of Islington's decision to revoke a certificate of lawfulness of existing use of development. So it's a CLEUD, we call those, and that's under section 1937 of the Town and Country Planning Act 1990. I think before going into the detail of the grounds for the JR and then the takeaway points and the judgment, it's probably worth just running through relatively briefly the facts, which are in the timeline on the slide there, starting with the original 1984 permission on the left, and then running through to the CLEUD being revoked in October 2020. So as I said, the original permission was from 1984, and the site in question was a terrace of units labelled A to D on an industrial estate, which were built pursuant to that permission. And the permission was for an industrial building to house BT, British Telecom workshops. And on that permission, condition 3 required the units to be used only as light on general industrial buildings. And it also stated that the buildings were not to be used as warehousing without express planning permission. And it's that condition with which we're concerned. So in the period up to Ocado's involvement, Telereal, which was an interested party in the JR, acquired the freehold, and they first leased the site back to BT and then subsequently to the Royal Mail. And during that period from circa 1992 to sort of present day, the site was used for B8 warehousing in breach of condition 3. And it's not entirely clear to what extent or for how long. which is why there's a question mark on the slide there. That's sort of the contention in the case, really. So fast forward to 2018, Telereal, as the freeholder, entered into negotiations with Ocado for release of the units for Ocado's use as a distribution centre. And one of the conditions of those negotiations was that the premises would have a suitable planning consent to provide for that use, so a distribution use. I think it was click and collect facility and also 24-hour use. So Telereal said to Ocado that they'd go forward and obtain a CLEUD to cover that off. So the CLEUD application which Telereal put to Islington was made on the basis that units A to D had constituted a single planning unit throughout the entire period, and that once the premises had been used for BA purposes for the 10-year period in breach of condition, which is the point at which the lawful right accrues, that right had not subsequently been abandoned. And the council, on having received the application, adopted that approach and granted the CLEUD in April 2019. Subsequently, November 2019, Ocado entered into the agreement for lease, and they also submitted a further planning application for essentially fit out works and improvement works. And on that application, there are various consultation requirements, unlike applications for CLEUDs. And as a result of those consultations, objections were attracted from a number of groups, including the concerned residents of Tufnell Park, who are one of a number of groups, who also included other groups such as NoCado, which I thought was a fantastic name for an objection group. So, having been alerted to the existence of the CLEUD as part of those objections, the concerned residents of Tufnell Park went to the council and asked them to exercise their powers to revoke the CLEUD, and those powers are under section 1937 of the Town and Country Planning Act. And the grounds under that section of the Town and Country Planning Act are that either information in the application was false in a material particular, or that material information had been withheld. And it was those grounds, both grounds, on which the application or the request was made to the council for the CLEUD to be revoked. The council revoked the CLEUD in October 2020, and there was an officer report associated with the revocation, which listed two reasons for that. So the first one was that, and quoting from the report, was that contrary to the basis on which the CLEUD was granted, the law in fact required a breach of condition to have continued for at least 10 years up to and including, which is the crucial point there, the date of the application for the CLEUD. And then the second point which the council made was that had the false statements not been made and or material information withheld, Islington would have been alerted to the need to carry out further investigations and could, rather than would, have come to a different decision. And those were essentially the two key points for the revocation. Those are the points which were then picked up in the grounds.
So far so good for NoCado then, as you say, fantastically named. But what Ocado obviously were unhappier than NoCado were. What were their grounds of challenge, Henry?
So obviously the application itself was made by Telereal as the freeholder, but the claimant in the judicial review was Ocado, because it was them who were seeking to use the site and rely on the CLEUD. So Ocado were the claimant, Telereal were an interested party. Initially, Ocado put forward 7 grounds, but subsequently withdrew ground 6. So there were 6 grounds that actually went before the court. I won't go through every ground in detail or even list them out, in fact, but I think that there were 2 key themes. So the first one was the question of the expiry of accrued rights, which is relevant to that 10-year point. And the second dealt with the grounds on which revocation could take place, which is around that point on false statements and withholding information. So just going on to the next slide there, please. So the first theme is around expiry of accrued rights, and that revolved around the assertion that the council had erred in law by proceeding on the basis that an accrued right relating to a breach of planning condition, which was subsequently legitimised by section 1913, and that deals with the 10-year period point, is lost if that right does not continue to be exercised. And that's the first point from the officer's report. The second theme was around false statements, and I'll come on to that later. So dealing with the first theme, I'll try and run through this fairly quickly because I think it's a more legalistic point, whereas the second one has perhaps got some more practical takeaways. So I think the two differing approaches were those that were set out in Telereal's application, which initially was adopted by the council, and then the second approach was the one set out in the officer's report for the revocation. And obviously Ocado were supportive of the position in Telereal's application. So in the application, the basis which was put forward in terms of the accrued right was that once the premises had been used for B8 purposes for a 10-year period in breach of condition, the use right was obtained. It didn't then need to continue, and as long as it hadn't been abandoned, it could be relied on for the application for a CLEUD. In contrast, the officer's report for the revocation was saying that the law required a breach of condition to have continued for at least 10 years, which is fine, but also that the breach of condition had to continue up to and including the date of the application for the CLEUD. So the difference essentially related to the dashed line on the slide and whether the continuity requirement had to continue up until the point at which the CLEUD was applied for, or whether it was simply a case of 10 years continuity followed by no abandonment. Now the court on this point ruled in Ocado's favour, so they favoured the argument that it was abandonment after lawful right accruing, and in concluding that the applicant, well, the application adopted the correct approach, the judgment highlights that the continuity requirement simply determines whether time is running for the purpose of achieving the 10-year period for immunity, so up to the first box on the slide. And that's based on the idea that time can only run when the planning authority is able to take enforcement action. Now, logically, once the 10-year time limit expires and the right accrues, the question of whether the authority can take enforcement action becomes irrelevant, as legislation states that the right is accrued and can be relied on. So Section 191, Town and Country Planning Act, which deals with application for CLEUDs, requires the authority to be satisfied with the lawfulness of the matter in question at the date of the application. It doesn't require that the lawfulness accrued or became lawful at the time of the application, and that's the key distinction. So what that means is the position on the slide is correct, in that there's a 10-year continuity requirement, the lawful right accrues, and then as long as you don't abandon that right, and there's a separate line of case law on that, which is summarised in Hughes, which is a Court of Appeal case. So as long as that doesn't become abandoned, a CLEUD application can then rely on the initial 10-year period. So that's really the first of the two themes.
And I think for me, Henry, it's quite an important point, because abandonment, which goes all the way back to Lord Scarman and his judgment in the Pioneer aggregates litigation, abandonment is not an easy thing for anyone to demonstrate has happened. So the mere fact you've stopped doing something doesn't mean that you've abandoned that lawful right. So I think for me, that's quite an important point, that the threshold for anyone trying to resist a certificate of lawfulness because the use has stopped, it's a high threshold, it seems to me, to get to that abandonment point. We could spend a long time debating the law on that, because abandonment, when it's one of those things that put two lawyers in the room and ask them to talk about abandonment, you'll get two completely different views. But certainly, I think we can probably all agree it is a high bar for anyone to show that someone has abandoned a lawful use, unless they've done something really quite obvious. It seems to me, starting an alternative use or whatever, doing something very different and contrary to an assumption of the existence of that sort of continuing breach. That's quite a key point. But anyway, you mentioned there was a second theme around false statements and withholding information, and that, I think you said, potentially has more greater day-to-day relevance for applicants. So what were the findings on that, and what are the key takeaways?
Yeah, that's right, Trevor. I think on the abandonment point, there are a number of places in the judgment where he very much says that it is a high threshold. So I'd certainly agree with you there. In terms of the second theme around withholding information or false statements, I think the takeaway points here are ones which relate to what should we be looking to do at the application stage for a CLEUD. So I'll come on to those at the end, but before we do that, I think it's probably worth just running through the issues which the officer's report for the revocation identified with the initial application. So there were a number of them, and I won't go through them in detail, but some examples were that the application didn't mention a lack of interconnection between units B and C. So if you remember, there were 4 units, A to D, and that was relevant to whether there was a planning unit established. Another one being that the application didn't refer to a statement in a 2011 planning application that units C and D were in fact at that time unused and had been marketed since 2006 as a separate unit. And I think the other theme of the issues in the officer's report was that there was a statutory declaration, apologies, which stated in a number of places that the whole site had been in use as a warehousing storage depot, and that use had been continuous, but didn't really provide substantive evidence to back that up. And as a result of the subsequent evidence, those were the statements that were viewed as being false. So in relation to the question of materiality, the court held that given the limited nature of the evidence provided in support of the CLEUD application, the LPA was legally entitled to consider that application had been, information had been withheld, unless that line of inquiry could not rationally have led to any different conclusion. So in essence, what the court is saying there is that this is a question of fact and degree, which is one of our favourite phrases. But what that essentially means, it's a question for the decision maker, subject to challenge on the grounds of irrationality. Another point which the court highlighted was that where an application was robustly supported by evidence, the authority is entitled to judge that the decision to grant a CLEUD was not materially affected, notwithstanding any false statements. So the point there is that there may be 1 or 2 false statements in an application, but as long as the other statements are robustly supported, the LPA is entitled to come to the conclusion that they still would have granted the CLEUD. The issue which was frequently referred to in the judgment with Taylor-Real's application was there were unsubstantiated points made, which then meant once there became an issue in terms of false statements or withheld information, there was nothing else to be relied on. So I think those are probably the main points around falsity and withholding. There are also another couple of points of interest that were referred to in passing. And one of those was one of the grounds which was put forward by Accade. So the first one is that Accade argued that the withholding of information had to be deliberate, but the court very quickly ruled and ruled out Accade's argument in that the withholding information doesn't have to be deliberate, and just the fact of withholding is sufficient, so it's an objective test. A couple of other points. First one being that the judgment highlights that the reference to material information is to information which the falsity or withholding of could, but not necessarily would, have resulted in the application for a CLEUD being refused. And that goes back to the fact and degree point. The point here being that the could standard is a far lower standard than would. However, for the purposes of the case, it was common ground that Islington rightly applied to the could test. And then I think second and probably last point of note for our purposes today is that the court pointed out that just because the LPA holds information in its database, so in that case talking about the LPA's planning portal, it doesn't mean that an applicant can't be treated as having withheld that information. So in this instance, I think it related to the 2011 application, which was referred to in the CLEUD application, but not expressly explained as to why that was a point of interest. So essentially, there's not an obligation on the LPA to search its records, and it's down to the applicant to put forward a full and candid summary of the facts. So I think that's hopefully a brief but useful summary of the points, and we can certainly pick up on other points in questions at the end. But for now, I believe Trevor's going to take us through a pair of recent High Court decisions in relation to nitrate release from residential developments. So Trevor, perhaps as a start point, at least for my benefit, you could explain what exactly nitrates are and why we should be concerned about them.
Thanks, Henry. Just before I do, I think it's just the point you've just made on the Accade case, I think is an important one, because careful how you frame your certificate in order to make sure it's robust. There is always a tendency, I suppose, to point out things that are useful and perhaps to gloss over the things that aren't. But it clearly has an impact on how robust it is. And I suppose the other aspect is for those who are, whether you're acquiring a site or whatever, if you're doing it on the basis of a certificate of lawfulness, just be alive to that fact that a certificate of lawfulness is not necessarily for life. And if things come to light subsequently that weren't before the planning authority, you are at risk potentially of losing your certificate, I guess. But yes, nitrate. I've taken on quite a task here because I've got two cases where there's an awful lot going on, and so I'm never going to get all of it covered in the time that we've given ourselves, Henry. So I'm going to try and concentrate on what I think are the most important things for people to take away. But if appropriate assessment or just nitrates are your thing, then the cases are certainly worth a read. But if we can go on to the next slide, which will reveal the two cases. So two related cases, the key one of which is the Wyatt case, but there was a case that's the subject of a separate judgment, but by the same judge and handed down on the same day, which is the Save Warsash and the Western Wards case. Both cases related to relatively small-scale residential development proposed in the village of Warsash, which is in Fareham, which is an authority that sits between Portsmouth and Southampton, down on the south coast, and critically falls within the Solent region. The Solent region being a large area that actually spans 12 local authority areas, so quite a big area, and it includes multiple protected sites, notably both special protection areas and special areas of conservation under the various EU regulations, and also several triple SIs. As the judge describes it in the case, it was an internationally, or it is an internationally recognised magnet for bird populations, particularly for waders and for wildfowl. And those protected bird species are threatened in the Solent region by increasing levels of nitrogen compound in the various watercourses. And so why are they threatened by those compounds? Well, in short, and without pretending to understand the science at all, an increase in nitrogen compounds in water results in an increase in algae growth, and that algae growth interferes with the ecosystem and ultimately leads to a threat to the bird populations that are sustained by the fish and everything else that lives in those rivers. So I think we've been aware of nitrate impact for quite some time. Anyone who's been involved with agriculture will know that the use of various fertilizers, pesticides, can increase nitrate levels via agricultural uses, and that has led for many years we've had controls on use of nitrates by farms within designated nitrate vulnerable zones across the country. But I think what this case does is highlight that it's not just an agricultural issue. And in fact, wastewater from residential and other development does contain nitrates. And that's even after it's been through the appropriate sewage treatment systems. And so treated wastewater from development, that effluent ultimately is discharged into local watercourses. And in the case of the Solent region, given that 12 local authority area that it covers, it is a wide catchment area from which that wastewater ultimately ends up in the protected watercourses of the Solent region, leads to this algae increase. So this has led Natural England to publish guidance on how to approach the issue within the Solent region. The guidance is not new in itself. We're on version 5 of the guidance at the moment, so it's been with us for long enough to have been through 5 versions so far. But the key thing in the current version of the guidance is that Natural England is clear that it considers that the additional nitrate content that comes from wastewater from new development in the region is likely to have a significant effect on several of the internationally designated sites in the area. The significance of that being, of course, that it triggers the requirement for appropriate assessment in the context of any planning application being brought forward. What Natural England's guidance goes on to do is, as is required under the habitats regulations, it seeks to apply the precautionary principle, and so its advice to local planning authorities is that only proposals that are at worst nutrient neutral should be permitted within that wide region. So it's all very focused on the Solent region in the case, but I think there's a wider application here as well, because while the case is focused on the Solent region and Natural England specific guidance, I think there are two issues that are relevant beyond the South Coast. The first is that actually the case sets out some very important principles that are generally applicable to the carrying out of appropriate assessment. And secondly, the case indicates that Natural England is intending to publish national guidance on the issue of nitrate content from wastewater discharge from new development, but it's specifically weighted before doing so for the outcome of this case. So it seems to me that the issues that are raised in this case for the Solent region may very well be coming to some, maybe all, development across the country very shortly. So we clearly need to be getting ahead around this issue of nutrient levels in wastewater discharge. Hopefully that explained some of nutrient and nitrates to you, Henry.
That's helpful. Thank you, Trevor. I've actually come across nitrates as an issue in a highways context as well, which is slightly different, but I think it's deposition essentially from exhaust fumes, which in a similar way promotes growth of certain things. So in your case, it's algae. In this case, it's growth of plants in sensitive areas. But as you say, I think agriculture is very much the area that you associate with it, isn't it? So I mean, in terms of appropriate assessment, what were the principles that came out of the case on that?
So I think all of the interesting stuff on the principles of appropriate assessment are in the Wyatt judgment rather than the Save Warsash judgment. There are a lot of them, so I'm not going to go through them all because I'm rapidly running out of time. But if anyone is involved with the preparation of appropriate assessments, then I would suggest that paragraphs 29 to 40 of the judgment are compulsory reading for you. So do have a look at those paragraphs where the principles are set out. A lot of the principles are derived from existing case law. It's not all new radical stuff, but it is a useful and a readable summary nonetheless. As I say, I'm not going to go through them all, but there is one in particular that Mr. Justice Jay in the High Court was considering, and that's the long-established principle that when a competent authority is considering the question of whether there is an adverse impact on a protected site, the standard of investigation is high, and that's in line with the precautionary principle. There's nothing new in that. We've known that for many years. The European Court has passed many judgments that tell us that. Particularly, people will probably be familiar with the Waddensey judgment of the European Court back in 2004, where the test was enunciated. And while none of that test is new, I think what is new is that the judge went on to consider what that means for a particular appropriate assessment. And the court's decision is that precautionary principle, that high standard of investigation, the need to ensure that there is no reasonable doubt as to the absence of adverse effects on the integrity of a site. What that ultimately means is that in any given case, there needs to be a case-specific assessment by the competent authority. And in the judge's words, that case-specific assessment needs to apply rigorous scientific principles to the endeavour, to quote Mr. Justice Jay. And I think that is a development of this principle around what the standard is. The fact it needs to be case-specific is new wording that we all need to be aware of.
So in terms of actually carrying out an appropriate assessment, Trevor, as I understand it, and it's referenced on the slide, the Natural England guidance was advising local planning authorities to assume a per dwelling occupancy rate of 2.4 people, which was based on a national average. Is that right? And how was that dealt with in the judgment?
That's right. So Natural England's guidance set out a methodology for calculating the likely nutrient levels resulting from any new development proposal, and effectively it was a balancing exercise, looking at the likely discharge from the wastewater, looking at any mitigation that was being employed, and arriving at a net figure to establish whether that requirement for at worst nutrient neutral development was met. And in doing that, Natural England was advising the use of the national average occupancy rate for England and Wales, which is published by the ONS, which is 2.4 people per dwelling. And in the Wyatt case, the planning officer had applied that methodology, and that resulted in a small net gain, so a positive position in terms of nutrient levels, where there was a small reduction overall once you'd considered the mitigation. But it was a very small reduction, so we're talking about sort of small margins here, where if any of the assumptions were wrong, it would very quickly have resulted in something that was worse than nutrient neutral. Mr. Wyatt had raised a number of grounds of challenge in the case, and it's fair to say the judge was far from impressed with many of them. There's some quite critical words in the judgment, quite unusually critical for a High Court judge, I think. But the one ground that really did find traction with the court was the criticism of using that national average occupancy rate of 2.4 in that nutrient budget calculation. And what Mr. Wyatt had argued was, well, he'd argued point in a number of ways, I suppose, but one of the ways he'd argued it was that the basis for the national figure didn't reflect the reality of the development that was being brought forward. This development was of 4 and 5 bedroom houses, so larger than average houses, and therefore his argument was that you would expect that the occupancy rate of a larger than average house was likely to be larger than the national average occupancy rate, and therefore the 2.4 figure was unsafe. And I think having considered the habitat regulations, the case law, and looked at the evidence in detail, the court concluded that Mr. Wyatt had a point, and that the use of an average figure as a general principle, in fact, may be problematic, given that principle that the judge had identified earlier of the need for a case-specific assessment. And so whilst the court accepted that there was an attractiveness in terms of simplicity of using an average figure, the court found it difficult as a matter of principle, I think, to accept that an average figure could be reconciled with that requirement for a case-specific assessment. And Mr. Wyatt also argued that the same point in a slightly different way. He had looked at locally available evidence, which suggested that locally the average occupancy rate was closer to 3. And the planning officer had considered that, but had dismissed that and had decided for various reasons to continue to use the 2.4 criteria. But the court indicated that given that occupancy rate locally of 3 was more specific and probably therefore more relevant, it may well constitute the best available scientific evidence in line with one of those other established principles of appropriate assessment. So real concern, I think, with the use of average as a principle, but also with the use of the particular average that Natural England had advised went into the appropriate assessment.
And presumably as a result, Trevor, the planning permission was quashed, was it, in this instance?
No, funnily enough, Henry, it wasn't. So even having found that, the judge wasn't with Mr. Wyatt on the overall case, and for me this is where it gets really interesting, I suppose, because early on in the judgment, when he was looking at his principles, he identified that the roles of Natural England, the planning authority, and the court are all very different. And for me, the key part of the judgment, alongside that question of whether an average figure should be used at all, a key part of the judgment is looking at what's the role of the courts in all of this. And what the court said was that the principles of appropriate assessment don't apply to the court. They apply to the appropriate authority. Those are the principles that govern the local planning authority carrying out that appropriate assessment and satisfying itself as to whether or not there is an adverse impact on the integrity of a protected site. But it's not for the court to then revisit that and to apply those principles again in coming to its decision. What they said was, this is a judicial review, and therefore it should be dealt with in the same way as any other judicial review. So on that basis, if a planning authority has considered all the material factors, if it's not taken into account anything that it shouldn't have done, and if it's properly directed itself as to what the law says, then the only way that that decision is challengeable on judicial review is on the basis of irrationality, or what we lawyers often call Wensbury unreasonableness. And that test, well established, is that in order to be irrational, the decision has to be so unreasonable that no reasonable decision maker sitting in the shoes of the particular decision maker could have come to that decision. And so while the judge was clearly very uncomfortable with the use of the 2.4 average, he was satisfied that the planning authority had considered everything that it ought to have done, including the question of whether to use the alternative figure. And that having done that and having understood that process, the decision simply wasn't so unreasonable that no reasonable authority could have come to the same conclusion. And so whilst I suspect, had the judge have been making that decision, had the judge have been the planning officer, he would have probably come to a different decision. He couldn't satisfy himself that the authority had got it so wrong as to be irrational, and therefore he dismissed the ground, having rejected all the other grounds as well, he upheld the grant of planning permission. So for me, two key takeaways, I think. One is that question of being very careful if you are using an average figure in an appropriate assessment. Then you need to be really challenging yourself on whether that is the right approach, whether that is a robust approach, but also that keeping in perspective the role of the court, and a reminder to all of us that it's not enough for a court to be persuaded that an error has been made. It's got to push it into that grounds of irrationality if you are looking at a Wednesbury type challenge. So that is in a very brief canter, and I'm conscious I've taken a little bit more time than I should, so we ought to go on to questions, but that for me is the big takeaway from those two judgments. So just coming into questions, we've had a question, or it's coming straight back to nitrates. So we've had a question as to whether nitrate runoff is just a problem in the Solent, and I think I mean the answer is no. I think it's an issue elsewhere, and as I say, that Natural England clearly are building up to some guidance that goes beyond the Solent rather, to cover us all. And Henry, you say you've come across it in a highways context as well, so that's another example, I guess.
Yeah, and that's in the north of England, so fairly distant from the Solent.
Yeah, fair point. We've had another question that's come through on the case, so let's just pick up on that one, which is a question, probably quite rightly, about what was the outcome in the Save Warsash case, because I didn't get to that in the summary I've just given. So on the substantive grounds, the Save Warsash case, the judge came to the same conclusion, and in fact he simply referred back to the Wyatt case when talking about the substantive grounds. But on the Save Warsash case, that case did ultimately lead to the quashing of that planning permission. There were two planning permissions on nearby next to each other. However, it didn't really have very much to do with the appropriate assessment principles we've just talked about. In that case, what had happened was there was a question coming back to that nutrient budget. There was a question about what the existing use of the land was, and therefore what level of nutrient runoff could already be factored into the calculation as already happening on the site. The applicant for planning permission had said that the site was used for grazing, horse grazing, and that would have led to a higher nitrate runoff than if it had simply been bare land. There was a dispute with the objectors as to whether it was in fact grazing land or whether it was bare land. Very close, I think it was a day or 2 days before the planning committee meeting, the applicant had put in statutory declarations confirming that the land was used for grazing. The objectors obviously didn't get that information until very late. It wasn't made available on the website until literally the day before committee. The objector then contacted the planning authority and said that they took issue with that evidence and they were prepared to provide their own statutory declarations to counter it, but they didn't have time to do that before the committee meeting. At the committee meeting, the council's solicitor had advised that given that there were statutory declarations, those should carry a significant amount of weight, and that therefore the authority had enough information in front of them to make the decision. The court disagreed with that, and the court said, actually, if that information has been provided late, objectors need to have an opportunity to counter that information. they had made it clear prior to the committee meeting that if they were given the time, they would have been able to provide statutory declarations of their own in contrast, and therefore they ought to have been given the chance to do that. Having not been given the chance to do that, they were left with with an impossible situation, and so the planning permission was quashed on that basis. So I suppose there's a timely reminder there that you need to ensure as a planning authority that all parties have a fair opportunity to contribute to the process and to put forward their own case in a proper way. So in terms of other questions, just bear with me as I'm looking down the list, and it looks as if we possibly come to the end of the questions. Sorry, I've just knocked my camera. It looks as if we've come to the end of the questions. So Henry, you got off lightly, which is probably just as well, because we're now at the 11 o'clock that we said we would end at. So if we can finish there, thank you to everyone for joining. I hope it was interesting. I hope it was useful. If you need any more information on any of that, please don't hesitate to contact either myself or Henry. And Henry, if I can just thank you for joining me today, and with that, say goodbye to everyone and look forward to seeing you all on the outline session in July. Thank you.
Thank you, everyone. Goodbye.